Hey everybody, welcome back to the channel today. We've got a special interview for you today as we have the CCW story ramping up. We got a nice success going on in San Francisco. To talk about it as a whole, though, we've got Costas Moros with us today. Costas, thank you for being with us. Costas is an attorney at Michelle & Associates. You've also seen him on Fox News weeding out the whole CDC situation, getting rid of the defensive handgun use statistics. So we've got a lot of stuff that we're working on there, but before we get into this, be sure to like, share, and subscribe to this channel. It really helps with the algorithms. It helps us get this information out to as many people as we can. We need to get this movement continuing to move forward, and we can do that by getting the truth out to as many people as possible. So Costas, I was really curious. So we do have the victory that we had in finally after years getting a CCW approved in San Francisco. Before we get into the weeds on that, can you just sort of take us through this entire process? Because it really started with the Bruin decision, right? So can you go ahead and tell us what Michelle & Associates did following the Bruin decision that led up to this today?
Oh, it's been quite the journey to get to just this single permit being issued in San Francisco, believe me. So after Bruin was issued, immediately, because we knew, although we didn't have the text of the decision, we had some idea of what was coming, what we suspected Bruin was going to say. I had essentially prepared letters to each of the counties, particularly the hostile ones, like San Francisco, like Santa Clara, warning them, or not warning them, telling them that now that Bruin is the law, they have to start issuing permits to regular people. There is no more of this favoritism where only campaign donors and rich and famous people get permits. So we sent that letter. Not days later, the Attorney General sends his own legal alert out in which he says, yes, good cause is gone, but you can do all this stuff with good moral character. For example, the most egregious one was he said you could, sheriffs could look at people's fiscal stability to determine if they had good moral character. If they had been arrested even without a conviction, that could be a sign of a way to deny someone based on good moral character. So that's the kind of thing California's done to resist. And these counties, their main thing is either listening to the Attorney General or alternatively simply stalling. We heard every excuse in the book, especially from places like San Francisco. Oh, we don't have the training class set up, even though, you have private trainings. Oh, we don't have a process for doing these background checks. We don't have this. We don't have that. So we had to keep up the pressure, constant communication with these counties. Lawsuits have been threatened. Everyone knows about Alameda at this point. And finally, we got word from San Francisco that they have approved the first permit post-Bruin.
Well, can you dig into Alameda? What exactly is the lawsuit in Alameda?
So Alameda, we haven't filed it yet, but we did send a warning letter to Alameda, and the reason we did this was specific. So I was pushing to file a lawsuit immediately in January, but I was kind of talked out of it by my wiser, more calm colleagues who said, look, there's a new sheriff in Alameda taking office. That makes it unique. Let's give her a chance, since she's a new sheriff, to make a change. Not a lot of time, but a chance. So we sent Alameda a letter with a draft complaint saying basically, here's our issues with what you're doing over in Alameda, and here's the complaint we're going to file if you don't change it. I did hear back from their county council a couple weeks ago, and we agreed. He said the sheriff is willing to make at least some changes, and we agreed to give them till February 10th to confirm what changes they're making. And if it turns out they're pulling our leg to stall for time, we will sue them. But Alameda specifically has all sorts of requirements right now under the old sheriff, at least, that were egregious. For example, they'll ask you about what kind of guns you own, what security you have at your home, who lives with you, where are your guns stored at home, all sorts of stuff that is none of their business, frankly. They don't need to know what other guns you own. They just need to know what guns are going on your carry permit. But I don't mean to get too into the weeds on Alameda. Hopefully they change their policies.
It's not really a surprise, and I can tell you that I've received a lot of, whether they're inquiries, frustrations, or complaints in general. The mass majority of them do seem to be coming from the Bay Area.
Yes.
I guess that shouldn't be the biggest surprise. That's where we have a lot of anti-2A people, and anti-2A people are going to elect, anti-2A representatives. It's been that way for a while, but so you're basically saying that in this area you've given it a lot of attention.
Yes.
And that attention goes directly to the sheriff's department. We've now seen a change in San Francisco. Is this something you expect to spread, or do you expect to continue and see this sort of resistance? Are we looking towards progression on this?
It's going to be 2 steps forward, 1 step back is my prediction, and let me explain why. So when the Bruin decision came out, the San Francisco sheriff put out a statement basically bragging that since he took office in 2020, not one permit had been issued. So that's what we were up against. Now they are finally starting, it looks like, to issue permits. However, I read an article last night in response to this news because ABC News and a bunch of others covered it, local news in the area. And city council people up there are already saying stuff like, well, we're going to pass our own sensitive places restrictions for San Francisco, basically making it so you can't carry anywhere. Another city council person, and I might be mistaking what exactly their position is, I believe it was a city council person, said that, might have been a supervisor, said that they're going to make permits harder to get, even though that's under the domain of state law. It's not actually their job to set permit issuance laws. So I think we are still going to continue to see resistance, but they're going to lose. I mean, the Constitution is on our side. We're going to have court fights, I'm sure, especially when California tries to change its carry laws in response to Bruin again. But we're gonna have some precedent, right?
I mean, we were talking right before we got on here about some cases in New York and New Jersey. You want to go through that? What's the precedent that's building in our favor right now?
Okay, so if everyone might recall how a bill called SB 918 almost passed here that would have made, in addition to making it harder to get a permit in California, it would have also made a permit kind of pointless by making nearly everywhere a sensitive place. New York and New Jersey did that. They passed those in the last New York in the summer, New Jersey recently, and there's already been a few different district court rulings striking those laws, or at least substantial parts of those laws, if not all of them. Now, though the New York ruling has been stayed on appeal, the Second Circuit stayed the district court ruling and allowed New York's law to take effect. And the plaintiffs appealed to the Supreme Court. And while the Supreme Court didn't reverse it, Justices Alito and Thomas did issue a concurrence saying, we're going to give the Second Circuit time to rule on this, but if they take too long, essentially, the plaintiffs should come back to us and ask for relief again. So the Supreme Court is watching this. And they called the district court ruling in New York a thorough ruling. So it looks like the Supreme Court is well aware of this issue, and that should put places like New York, New Jersey, and of course California on notice. Oh, and one more point about precedent. We have our Glendale case, which is currently proceeding. While that won't be as expansive as what California is going to do, it looks like Glendale is going to be opposing us on at least a few places, like parks, playgrounds, libraries, and one other I'm forgetting. So that could set some early precedent in our favor before the new California carry law passes.
Well, and one of the things that in my mind I always end up mixing up is the fact that these are checks and balances, but that's exactly what they are. The way that our system is set up, our legislature can literally pass anything that they want. They can make red lights illegal if they want to. It's the balances of the court system that end up checking that. So, we could have precedent that is set at what you're saying, the Supreme Court level with sensitive places. That's not necessarily going to stop the California legislature from passing a bill that makes all of California a sensitive place. But the question that I have for you is, how does that precedent actually expedite our lawsuits after that happens? So you get the California legislature that passes the unconstitutional law. There's already legal precedent saying you can't do that. We end up filing a lawsuit. Does that have the same path as, say, maybe the Duncan case that got filed in 2016 and we're still fighting it here in 2023? Or is there an expedited process for this?
I think the fact of the Bruin decision's existence makes it faster, because when Duncan was filed, there was no Bruin decision, and Duncan had to deal with precedent that had tried to narrow Heller for a decade. It had hollowed out Heller, and part of Duncan's mission was to restore Heller, and it ended up going up to the Supreme Court, and the Supreme Court remanded it because of Bruin. The difference here, we don't have binding precedent yet because Second Circuit and Third Circuit, New York, New Jersey decisions aren't binding on Ninth Circuit courts, but they are persuasive authority just by its very nature. If you show one judge, hey, look, this is what 2 or 3 other judges ruled, that's persuasive to them. They might not convince them, but they look at that. They take their colleagues' opinions seriously, and if other judges have looked at this issue, it helps persuade a judge. So we have that on our side. Our hope is, of course, we have no guarantees. I hope I'm not here in 7 years still talking to you about sensitive places. That would be very depressing. But I do think, prediction, don't hold me to it, I do think this is going to move much faster, especially because the difference here is we know the Supreme Court is watching because of that concurrence that Thomas Nolito filed in that emergency relief petition in New York.
Yeah, and they've already gone into such depth specifically talking about how you can't make sensitive places like that. But I guess back to the main point that we stemmed from here, this is a success in San Francisco, getting this CCW. I think it's more appropriate to look at it as a symbolic success. Yes. Obviously, there's still a lot more work to do. So what is that work, and what's the framework that you have looking forward on this?
Well, I've already told the San Francisco County Council, first of all, I told her that this is a good first step. That's good that San Francisco is finally moving in the right direction. And she told me that because they had to set up all these processes for the very first permit that they approved, she does believe that the rest will now go faster because now those processes are in place. I hope she's not pulling our leg there. I hope that's honest. But I did tell her that we would like to see San Francisco get its permit applications processing times down into the 90-day requirement. It might not be overnight. CRPA is not unreasonable. We know when you go from 0 to 100, it might take a little time, but we need to see good faith here. So if they can't do it in 90 days, at least do it in 120. Right now, what's happening is it's taking over 6 months, right. 7 months, 8 months to get. I mean, just this first permit, Bruin, happened in June, and now we're at the end of January, and they finally approved one. So that's, I think, 7 months just to get one. Right. So that's a problem. And I did warn her that, look, we are considering filing this lawsuit against Alameda if they don't confirm that they're making changes. And it's not exactly very hard to add San Francisco to that lawsuit. It's in the same federal district court. It's going to be a lot of the same claims. So I'm not against that option if San Francisco doesn't confirm that they're going to speed things up. Same goes for Santa Clara and perhaps even Contra Costa, I've heard things about. So those are the counties we're mostly watching.
Well, we're going to keep an eye on it, and we're going to see how that goes. Hopefully, it doesn't come to that, and hopefully we don't have to wait in court for years. Hopefully they just abide by the rules yes. and the laws. But I guess don't hold your breath for that. Kostas, I really appreciate you coming on with us, and we look forward to next time having you on.
Thank you so much for having me.
And if you continue to be interested in this story, please go ahead and check it out. We'll be following along on crpa.org. We're going to try to keep you as updated as possible. Once again, we are on the road to 10,000 subscribers. So if you haven't already, please feel free and like, share, and subscribe to these videos. Again, it always helps with the algorithm. Thanks, guys, and we'll see you on the next one.